What we're doing here today is we're having a discussion about Indigenous laws and specific claims. And the question before us is, why do Indigenous laws matter? Indigenous laws are needed because the specific claims process is broken. It's broken because it's a process that's one-sided, it's a process that's being imposed, and most importantly, Indigenous laws are needed because justice can never be achieved in a process of exclusion. Justice can only be achieved in a process of inclusion and very real and open dialogue. And so looking at specific claims and asking where is the space for Indigenous laws in this? Indigenous laws have very powerful things to talk to us and tell us, first, about what is the cost? What is the cost, not in terms only of money, although financial aspects will certainly be a part, but what is the cost to Indigenous peoples' cultures, languages, laws, to entire nations and communities of people for failing to set aside and honor the promises that Canada made? What is the cost? So Indigenous laws could speak to a broader notion of cost. Flowing from that, Indigenous laws also speak to a broader notion of how do we move forward? How do we resolve this? The specific claims process, as everyone who's involved in these discussions knows, has been one of structural inequality. It's been plagued by allegations of conflict of interest. Indigenous peoples have been very clear that this process itself is not fair because it's a process created by Canada, exclusively funded by Canada. Canada gets to decide which claims it will accept and reject. It even creates the mechanisms for hearing and the mechanisms for appeal. Recognition of Indigenous laws is necessary to move forward from a process like the one we have today that's imposed on Indigenous peoples toward one that's more in partnership with Indigenous peoples and that's owned by and considered fair and just by both parties, because you can't have fairness, you can't have reconciliation, you can't impose justice. Justice at its core is something which is mutual. It's something which is a shared endeavor. And that's the heart of the cry for the recognition and incorporation of Indigenous laws, that at its heart, justice is shared. Justice is never imposed. How can we, as societies, as people, come together and say, hey, we need to solve this, and our laws have new ways of talking about this, and you need to listen to that. So what might that look like, and what are some of the problems if we start looking at this from an Indigenous laws perspective? Where you see one of the biggest differences between Canada and Indigenous peoples is the idea of how we evaluate claims. So under an Indigenous laws perspective, you would look at more than merely the monetary value. You would look at the relationships, for example, that have been disrupted, and would not look at compensation merely as money that's paid to compensate for damage that has been done, but we would more start to look and ask, how can we begin a process of restoration? If we wanted to recover, restore, try to fix the situation, what would that include? For example, if a fishing station was failed to be set aside, and because of the loss of that fishing station, that meant that families within the community or the community as a whole then lost the ability to teach their upcoming generations about the fishery. That would have been a huge cultural loss. That may have meant losses of knowledge about the laws that were tied to the fishery or the language that was tied to the fishery. So for Indigenous people, simply looking at the cost of the little piece of land that was the fishery itself won't actually address what the actual cost was to the communities. When each of us, when each of the nations start to look at our own laws and ask, how can we bring our laws to bear? How can we begin the process of articulating or calling forward our laws in the area of specific claims? One of the areas that's very clear, and it's a very clear area across the country, Indigenous peoples have always had laws in this area, and that has to do with the treaties or protocols that we made amongst each other to resolve issues such as territorial or resource-based disputes. And so when we're looking at How do we resolve disputes with Canada about a failure to honor promises they made about territorial disputes? We look at those sort of laws that we have within our own nations, protocols for how we settle border disputes, how we settle land disputes. How would an approach based on Indigenous laws be different? I think that there's a few key areas that we'd have to look at. Western law is, for the most part, very people-centric. It's focused on what are the rights of people, what can we do, how can we use the land, how can we use the resources. Indigenous laws, although expressed differently because we have different nations, different cultures, different territories which are reflected by those laws, but universally what tends to be the same, although expressed differently, is that Indigenous laws very much tend to be concerned with the interrelationship of Indigenous peoples with the territory and the other beings which share it. So Indigenous laws equally will talk about how we preserve the right of the bears, the birds, the fish, the other plants and animals. So Indigenous laws will be very concerned with that whole set of relationships. We see Western law trying to move in that direction, but it's not there yet. But part of the discussion that we have to have if we're going to talk about specific claims from an Indigenous legal perspective is that the disruptions that happened aren't just to the people. There's going to be disruptions that Indigenous peoples find very important and want to talk about that are disruptions of the relationship of the rest of the living world to the territories that weren't protected. One of the things we know, absolutely without a doubt, is that Indigenous peoples from coast to coast to coast are diverse. Our laws, my people like to say that our laws arise from the land itself. So the legal regimes in place in different territories reflect the character of the land itself. And so if we want to talk about Indigenous laws and incorporating them into specific claims resolution, we also have to take into account the beautiful plurality of legal traditions. And so it's not a one-size-fits-all. It's that we make space within our consideration for the incorporation of the different Indigenous laws and legal principles of the Indigenous peoples across the country. So one of the important areas that we really need to look at, and when we start looking at Indigenous laws, one of the most powerful areas of Indigenous laws that we're aware of when we compare Western and Canadian law is that Indigenous laws universally recognized the power and place of Indigenous women. So these were sets of laws across the country in different expression that recognize the power of women. And one of the most painful and damaging aspects of the process of failing to set aside lands or failing to reserve lands or resources, that process that gave rise to specific claims, has to do with the impact on women. And there's a couple of very key areas that need to be looked at. So for example, the reserve creation policy in some cases set aside specific resource uses. For example, maybe hunting areas, in particular fishing areas. But in some of the cases, because the people who were setting aside the reserves coming from this Western tradition didn't even think that women could own land tenure, have an interest in resources. So as a result of that, no one in this process asked, which resources are important to the women? Which resources maintain the economy insofar as Indigenous women are part of that and how they contribute to it? So those resources, berry picking grounds, other areas, may not have been set aside. A couple of other areas are very important in terms of looking at Indigenous women in particular. One of the largest areas overall is the imposition of the reserve creation system at the same time as the status provision of the Indian Act deliberately denied status to Indigenous women and their children, where either they married non-Indigenous men or where they had children with non-Indigenous men, meant that many, many Indigenous women were then legally excluded from living on reserve lands. In many cases, then those lands were simply taken. So first the women were removed from the lands, and then the lands were removed from the reserve. The failure to reserve lands, or the breaches, the cutoffs, the forcible moving of communities, the failure to honor treaty promises, that oftentimes the cost of that, although monetary certainly, we don't want to ignore that part of it, but the actual costs to the community and to the people are far broader. For example, it could impact on feelings of safety, feelings of dignity, ability to be self-sufficient. This is huge. Reserve creation, or the failure to set aside or protect reserves as promised under treaty or under policy, had a remarkable and devastating impact on traditional economies of Indigenous peoples. Related to that is the ability of Indigenous peoples to actually meet their legal obligations to their nation, to their community, to their family. So sometimes when lands or resources weren't reserved or set aside, it didn't just disrupt the reliance on that resource. If there was a family, a community who had a responsibility to harvest that resource and then share that within the nation or share that within the community, that disrupted that too. So it was a very large disruption that needs to be addressed. We've mentioned this before, but also the loss of language and culture. A lot of language and culture, it doesn't just exist in the air, it's very land specific. These are tied to lands and resources. Our languages are the way that we're connected to our land, connected to the past. And when we lost access to land because lands weren't set aside, sometimes what happened is languages tied to that were lost. The laws tied to that were lost. Another disruption has to do with the fact that some laws may be held with particular hunters or fishers or resource gatherers, and then those would be laws that are learned and shared and passed forward in an active practice of harvesting on the land. So if the lands tied to those particular practices weren't reserved, what may have happened is a fairly severe cultural and legal disruption, and that's something that needs to be addressed as well. Shared and not imposed decision making, I think, will be one of the most powerful aspects of the incorporation of Indigenous laws, because Indigenous laws in all of their forms and in whichever way different nations and peoples decide to go forward will incorporate ways of actually listening to the people and looking at new ways potentially of how we have discussions, how we describe justice, how we move together in a way that's considered fair and just by both parties. And it really is, for Indigenous peoples, an issue of access to justice, because there can be no justice in terms of resolving historical disputes if we don't meaningfully and in a very real way, with a commitment to incorporate them. We need to look at Indigenous laws and we need to say, how can we make this how can we make this a reality? How can we actually move forward based on these, not just based on a discussion of these, but that will require a willingness to do things differently, to shake things up, to ask what is resolution, what is the process we follow, what are we willing to look at, and what's the process that we're willing to look at it. But justice requires this of us. An approach founded on Indigenous legal traditions for resolving specific claims is required, in which there's a space for Indigenous legal plurality. So we recognize and make space for different Indigenous legal traditions. That resolution is ongoing. That there's expanded notions of resolution. So we don't just look at money as compensation. We start to look at what matters from an Indigenous perspective, what restoration might need to occur, and we start to ask, how can we get that done, as opposed to how can we find a way to shut that conversation down. A multi-perspective approach is utilized. So what does that mean? That means that for Indigenous peoples, sometimes it's not just about looking at the cost to ourselves as a result of broken promises. that we might start also to look at what the cost is to the entire ecosystem, that we might start looking at what the cost is to the other living things that we share the land with, and find a way to incorporate those relationships into resolution. And finally, that shared, not imposed decision making is the cornerstone of a new approach. One of the very powerful differences I think that we'll see when we start to incorporate and really meaningfully look at how we can operate moving forward based on a recognition and vitalization of Indigenous laws is the fact that for Indigenous peoples, laws are very grounded. Laws are based in the land. Right now, the specific claims process, although it has to do with grievances based in the homelands of people, very important areas that are dear to the hearts of people, these are resolved in boardrooms or on paper. These are resolved far from the land. And I think one of the things that we have to be open to is that if we start to look at resolving things from the perspective of Indigenous laws, that some of that decision making will actually move to the land itself, that we'll look at the territory, we'll look at the resources, and so the very real nature of the loss, the very heartfelt nature of the relationship was disrupted, will start to be reflected in the resolution process.